Okay, I'm going to turn it over to Rick to begin our presentation.
The purpose of today's webinar is to provide an overview of the ongoing provincial challenges to the federal carbon pricing law, and we'll also explain how and why this case matters to our client communities at CELA. So if we can go to the next slide, we'll provide the roadmap to today's webinar. Thanks. So I'm going to kick things off by discussing the general background, the public policy context, and the basic chronology of events. Then Jackie will review the constitutional issues that are in dispute, and she'll summarize the opinions of the Saskatchewan Court of Appeal and the Ontario Court of Appeal. And then Theresa will review why this case is of profound interest to low-income and vulnerable communities, not just here in Ontario, but elsewhere. And as Jackie indicated, we'll leave some time for questions and answers towards the end of the webinar. So I think we're ready for the next one. Thank you. So let me set the stage by briefly reviewing the background to the two references. Of course, public and governmental and international concern about climate change is not new. In fact, this concern goes back several decades, but you'll be relieved to hear that I'm not going to summarize decades of environmental history. Instead, I'm going to choose the 2015 Paris Agreement as my starting point. And as most of you know, the Paris Agreement describes climate change as an urgent and potentially irreversible threat to human society and the planet. And that's why the Paris Agreement commits countries to limit average temperature increases to 1.5 degrees Celsius above pre-industrial levels. Canada ratified the Paris Agreement in October 2016. And then starting in December 2016, virtually all provinces adopted the Pan-Canadian Framework on Clean Growth and Climate Change, and that framework identifies carbon pricing as a key mechanism for reducing greenhouse gas emissions. So Ontario signed the framework, Saskatchewan did not. And then a year or so later, the federal government introduced and then enacted the carbon pricing law. It took effect in June 2018. That's on the third bullet point of this slide, the Greenhouse Gas Pollution Pricing Act. And that's the legislation that is at issue in the two constitutional references. I think we're ready for the next one. So in particular, it's Part 1 and Part 2 of the federal law that are in dispute. Part 1 establishes a fuel charge that increases over time. The current national benchmark for carbon pricing is $10 a ton, and that increases to $50 a ton by 2022. And in Ontario, this benchmark translates into a charge on gasoline of approximately 4 cents a liter, payable at the gas pump, and that will increase to 11 cents a liter in 2022. And you'll see all of that set out in glorious detail in the gas pump stickers that will be arriving at a gas station near you soon. But it's important to recall that 90% of the revenue generated through this fuel charge is actually returned to Ontario residents as a climate action payment in the form of an income tax credit. And that's to incentivize behavior that will reduce or limit greenhouse gas emissions. So that's Part 1 of the Act. Part 2 of the law establishes what's called an output-based pricing system for large industrial emitters. In very basic terms, these emitters must pay a price or acquire emission credits if they exceed the standards set for their particular sector. So I think that's it for that slide. Now, it's important to recall that the federal law does not apply in all provinces. It really is backstop legislation. And for provinces that already have a sufficiently stringent price on carbon through either a cap-and-trade system or a carbon tax program, the federal legislation does not apply. A good concrete example would be the province of British Columbia. It's had its own carbon tax program for quite some time, and so the new federal law does not apply to BC and certain other provinces. And as we move to the next slide, you can probably anticipate where I'm going. The new legislation does, however, apply in Ontario. Prior to the enactment of the federal law, Ontario did have its own cap-and-trade system, which was fairly well regarded and seen as successful by a number of stakeholders, including the Environmental Commissioner of Ontario. But you'll recall that last July, after being sworn into office, the current Ontario government terminated the cap-and-trade regime that had been enacted by the previous government, and that's what triggered the application of the federal law in this province. So all of that legal and political maneuvering kind of begs the fundamental question, which is, why are we concerned about climate change at all? In my view, the preamble of the federal law hits the nail right on the head. I think we now know that greenhouse gas emissions present an unprecedented risk to the environment, to biodiversity, to human health and safety, and to the economy. That's why we need to take measures now. And I think it's fair to say that the overwhelming scientific consensus is that climate change can and will cause a wide variety of adverse impacts, such as increases in extreme weather and heat waves and drought, wildfire, flooding, increases in disease, et cetera, that we've already seen in Ontario. And I would point out that none of these impacts were disputed or contested by any of the parties in the two references, including Ontario or Saskatchewan. Everybody concedes that this is a real issue. The question is, how should we best tackle it? And I think it's no surprise to most of us on this webinar that Ontario already is experiencing climate change impacts, and that's why it's incumbent on the Ontario government and all Ontarians to take swift and effective measures now and not 30 years out in terms of mitigating and adapting to climate change impacts. I put a reference here on this slide to Ontario Regulation 241/19. And I find it very interesting that having campaigned against carbon taxes and having killed the cap-and-trade program, the Ontario government quietly passed this new regulation in July that, in my view, essentially reestablishes a cap-and-trade system in Ontario for large industrial emitters. Basically, you have to acquire or use or purchase emissions credits. But I would point out that this new regulation only kicks in if the federal government agrees to stop the application of Part 2 of the federal law in this province, and whether or when the feds would be agreeable to doing that, I think that remains to be seen. I just wanted to mention that the concern over climate change is not just being brought by environmental groups or citizens groups or First Nations. You know, our independent environmental commissioner has also reported that we're in some serious trouble in this province. The province itself is warming faster than the average global in terms of temperature increases, and as well over the next 30 years, the annual temperature increase is expected to range between 2.5 to 3.7 degrees Celsius, with even higher increases anticipated in the north. And again, that's why we at CELA submit that it's necessary to take timely and effective and equitable measures as soon as possible in Ontario. This is not something that can be deferred or kicked to the future. So this brings me finally to the chronology of basic events. I would say the constitutional references are really the only game in town right now, at least until the next federal election. Most of you will know that both the Saskatchewan government and the Ontario government asked their courts of appeal to determine whether or not the federal law is unconstitutional. These references were heard earlier this year. Jackie and Theresa participated in the Saskatchewan reference in February in Saskatoon. My CELA colleague Joe Castrilli and I participated in the Ontario reference in April in Toronto. So I guess you could say Joe and I won the coin toss. In any event, in May, the Saskatchewan Court of Appeal concluded that the federal law is constitutionally valid. And in June, the Ontario Court of Appeal also concluded that the law is constitutional. However, that's not necessarily the last word. Both of these judicial opinions are headed to the Supreme Court of Canada for a possible hearing in January, just a few months down the road. So that concludes my introductory remarks, and now I'd like to turn things back to Jackie for her overview of the actual court opinions.
Great, thank you, Rick. So as Rick mentioned, both courts of appeal upheld the law as valid, and they did so under the national concern branch of the peace, order, and good government power. So I'm going to spend most of my time looking at the POGG power in those decisions, and then I'll briefly summarize the tax arguments that were made and rejected in both courts, and then outline CELA's argument as an intervener in both cases representing an environmental NGO and a faith-based organization. Turning to POGG then, the first step in any division of power constitutional analysis is to consider what's called the pith and substance of the act, which is the law's essential character, and you look at both its purpose and effect. I've put up on the screen here the many different ways that this was understood in the two courts. Canada proposed a broader way of looking at the pith and substance and matter, and first proposed greenhouse gas emissions as a matter, and then changed it slightly to be the cumulative dimensions of greenhouse gas emissions. Both courts rejected that characterization of the matter. And instead, what they found is that the Saskatchewan Court of Appeal found something quite narrow, which is that the establishment of minimum national standards of price stringency for greenhouse gas emissions was the matter. And the Ontario concurring opinion found something very similar. So there was a 3-judge majority in Saskatchewan that found that narrow matter, and a 1-judge concurring opinion in Ontario that found a very similar matter of establishing minimum national greenhouse gas emissions pricing standards to reduce greenhouse gas emissions. The majority of the Ontario Court of Appeal found something a little broader as the matter, which is the minimum national standards to reduce greenhouse gas emissions. So the difference between those two majority opinions in Saskatchewan and Ontario is whether you recognize pricing as part of the essential character of the Act. Theoretically, the pith and substance analysis and the analysis of the matter under a POGG are distinct analytically, but in reality they overlap very heavily in both the judgments, because when you're dealing with POGG, you need to figure out exactly what subject matter is going to be covered by the new matter that you're recognizing. In a division of powers analysis with an enumerated ground, the matter is just what's already listed in the Constitution. But in this case, and in any case dealing with the POGG power, the matter has to identify the contours of the new power. And that's quite significant, because when the matter comes under the POGG power, it means that it's within the authority of Parliament alone. And you'll see in both of the decisions that the courts were very much attuned to that concern, noting that a broad characterization of the matter, like what Canada suggested, could significantly alter the way powers are allocated between Parliament and the provincial legislature and alter the balance of federalism itself. And of significant concern is that if a broad matter is recognized under POGG, provincial legislation on the same matter wouldn't be valid. So the many provinces that have their own greenhouse gas pricing regimes already in place may have difficulty if the POGG matter is too broad. So in looking at how the matter should be described, the courts found exactly as they did on the pith and substance analysis. So the Saskatchewan Court of Appeal majority and the concurring Ontario opinion found that narrow establishment of minimum national standards with price stringency for greenhouse gas emissions as the matter. And the Ontario Court of Appeal found that minimum national standards to reduce greenhouse gas emissions without mentioning pricing was the matter. Once that's established under the POGG analysis, you move to the Crown-Zellerbach test. Crown-Zellerbach is the leading POGG case, and it's a case that recognized a federal POGG matter of marine pollution. So the first step of that test is to look at whether all parties were, whether there's a matter of genuine national importance. And as Rick mentioned, all parties were in agreement and didn't challenge the evidence about climate change being an important issue, of the significant impacts of climate change. And the Saskatchewan Court of Appeal noted that climate change is of superordinate consequence. However, where the disagreement lies is because of the way the matter is characterized, the provinces challenging the Act, Ontario and Saskatchewan and other interveners, do not agree that there's national importance or genuine national importance to having national pricing standards. What both courts found is that there was, in fact, national importance to having these standards. The Saskatchewan Court of Appeal found that greenhouse gas pricing is regarded as an essential aspect or element of the global effort to limit GHG emissions. And interestingly, the Ontario Court of Appeal linked this question of genuine national importance to Canada's international obligations, saying that those obligations are pertinent to determining whether the law is important to Canada as a whole. The next step in the POGG analysis is whether the matter has a singleness, distinctiveness, and indivisibility, which clearly distinguishes it from matters of provincial concern. The two court findings on this issue are very similar, and they found that greenhouse gases have specific chemical and scientific characteristics that allow you to distinguish them from other gases. When they combine the atmosphere, they become persistent and indivisible in their contribution to climate change. And both courts also found that there was no difficulty drawing distinctions between this act and the national pricing standard or backstop that was set, and either other regulatory approaches to fighting climate change that other provinces wanted to pursue, or provinces bringing in more stringent pricing standards. And finally, in this category, you also look at provincial inability to deal with the issue. Both courts found that the failure of one province to take action in respect of greenhouse gas emissions would have impacts on other provinces. And they were concerned about carbon leakage, which is when heavy industrial emitters move to other jurisdictions with lower environmental standards to avoid regulation. The Ontario Court of Appeal gave the example in this provincial inability analysis of the territories and Atlantic provinces, which are very low emitters and make up very little of Canada's total emissions, but are heavily and disproportionately impacted by climate change impacts. And they can't do anything practically or legislatively to address the rest of Canada's emissions, of course. And finally, the last piece of the POGG argument is, will recognizing federal authority over the matter have a scale of impact on provincial jurisdiction that is reconcilable with the fundamental distribution of powers under the Constitution? Both courts found that it could, and it's critical in this case that they interpreted the matter narrowly. They were finding that other provincial action, whether another regulatory approach or similar pricing, would still be constitutionally valid and there'd still be space for it because of the way that they interpreted the matter so narrowly. Turning briefly then to the tax argument that was raised and rejected in both courts, Saskatchewan, the AG of Saskatchewan argued that the Act fell under Section 91.3, the federal taxation power, but then argued that the law infringed Section 53 of the Constitution, which requires that tax bills originate in the House of Commons. That argument was based on the authority in the Greenhouse Gas Pollution Pricing Act to delegate to the federal cabinet to decide when and where the tax applies. The Saskatchewan Court of Appeal rejected this argument and found the levies were regulatory charges, not taxes, and in any event, if they were taxes, they were valid. Ontario raised a slightly different argument and argued that the Act was a regulatory statute, but that the charges were unconstitutional because there was no nexus to the purpose of the Act. Ontario's argument was based on the revenues being generated by the charges being returned to people in the provinces, for the most part, and there being no restrictions on how that money that was sent back could be spent. The Ontario Court of Appeal agreed that the charges were regulatory charges rather than taxes, but found that they were valid. And when regulatory charges are themselves used to alter behavior, whereas in this case, the price on carbon and other greenhouse gas emissions is intended to alter your behavior, they do not need to reflect the cost of administering the scheme or be a cost recovery mechanism. And in any event, the Ontario Court of Appeal found that the way that the refunds were structured, being a base amount for people of a certain family size, and then there's some differentiation depending on where you live, the refunds do reward people who reduce their emissions more. Okay, finally, turning to CELA's argument, we argued on behalf of an environmental NGO and a faith-based organization two alternative heads of federal power, the criminal law power and the trade and commerce power. There were other interveners that supported these arguments and also added others, such as the emergency branch of POGG, Section 35 of the Constitution, and charter arguments on behalf of youth. Because POGG raises concerns about federal overreach and unbalancing federalism, and in fact it's included in that test for POGG, the concern there was certainly front and center in the two judgments. Other heads of power, like the criminal law power, don't raise those same concerns. And we are quite keen on the criminal law power because it's been used multiple times to uphold federal environmental laws, including the Hydro-Quebec decision, which found that the Canadian Environmental Protection Act, which is the main federal statute dealing with toxic substances, was constitutional under the criminal law power. And the criminal law power has also recently been used to uphold a climate change law at the Federal Court of Appeal relating to renewable fuel requirements. Interestingly, in the Hydro-Quebec case, POGG was the main argument put forward by the federal government throughout all levels of appeal, and was his main argument at the Supreme Court of Canada, but the Supreme Court of Canada ultimately turned and upheld the statute under the criminal law power. So briefly, the criminal law power is a three-part test. There needs to be a legitimate public purpose associated with an evil. There needs to be prohibitions backed by penalties. And the act can't be a colorable attempt to invade provincial heads of power. In terms of the purpose, there's lots of precedent that protection of the environment is a valid criminal law purpose. Environmental evils have been recognized in cases dealing with climate change, as I mentioned the renewable fuels requirement case, reducing toxic pollution, and protecting species at risk. And there was no challenge in either case, as we've mentioned, to the evidence regarding the evils and impacts of climate change. And including, we might add, in Saskatchewan, there's a specific finding that the risks of climate change are unevenly distributed and are generally greater for disadvantaged people and communities in countries at all levels of development, including Canada. In terms of the prohibition and penalty, the Act establishes sanctions for emitting greenhouse gases without paying a charge. The court has repeatedly found that highly complex regulatory schemes can be upheld under criminal law as long as they're backed by prohibitions and penalties. Parliament also isn't restricted in its choice of means to address the evils. The prohibitions don't need to be direct or total. Parliament chose to address, for instance, the evil of tobacco by prohibiting tobacco advertising and requiring health warnings on tobacco packages, but didn't ban tobacco altogether, and that was a valid criminal law. And finally, in terms of colorability, there wasn't any suggestion in either court that the Act isn't really targeted at reducing greenhouse gases or addressing climate change, and so that wasn't a particularly live issue in either case. And finally, turning to our second argument, the trade and commerce argument, we argued that Part 2 of the Act, which deals with the industrial intensity-based greenhouse gas trading regime, that it could be upheld under the trade and commerce power. For a couple of reasons, based on the General Motors case, which is that the legislation is a general regulatory scheme. It's monitored by a regulatory agency. It deals with trade as a whole. And like in the POGG analysis, the trade and commerce analysis asked whether the provinces could collaborate towards the same goal. And what the court found in the POGG analysis, and which applies to us as well, is that the provinces could not, and Part 2 would be jeopardized if all provinces didn't participate. Okay, I'm going to turn it over to Theresa.
Okay, can you hear me, Jackie?
Yes.
Great. Thank you, and we'll go to the next slide. So the other thing we wanted to talk about today is why does this particular case matter to our client communities? And one of the things that we know and has been determined through academic research and empirical experience is that climate change is affecting and will continue to affect low-income and vulnerable communities more than others. And there are a number of reasons for that. One of the reasons is simply that lower income communities don't have the resources to purchase mitigation to offset the impacts on them. They may not be able to afford better housing or to move to a safer location or to purchase air conditioning if that's what was needed. Often they don't have insurance and don't have a way to rebuild housing if it's impacted by a storm. And we've seen that in many communities worldwide happening already. For many communities who are lower income, housing is less resilient in the first place, maybe doesn't have insulation that's as good, for example, and not able to withstand extreme heat or extreme cold or the things that come from high heat and high humidity like mold. And often that housing is also located in situations more likely than wealthier communities to be impacted by changing climate. So examples that we've seen all over the world include, for example, flooding and hazardous locations, as well as storms and heat and storm surges and many other climate-related issues, in addition to fire and others. There are specific characteristics of many vulnerable communities that may make them more prone to impact from heat-related issues. So, for example, in some of the heat-related deaths in Montreal, we probably have heat-related deaths in Toronto, but they're not being tracked, as far as I understand it, the way they are in Montreal. But for the last couple of years, we've seen the numbers being reported by Public Health in Montreal during heat waves. And the findings are that some of their medication makes them much less able to regulate their body temperature properly in response to heat, and they may not be able to leave their unit to go to cooling centers or a safer place. Children as well are less able to respond to extreme temperatures, and this is because of the large amount of surface area they have relative to the size of their body, because they're small, and this changes as we get older and have a more adult-sized body, and they also don't have a fully functioning regulatory system yet. And then poverty in general exacerbates all environmental health impacts. So all of those things mean that we're especially attuned to climate change impacts here at CELA and in the environmental community. Next slide. The other thing that Jacqueline's been speaking to in detail for you is the jurisdictional authority over this subject matter. And being the specialty clinic under the legal aid system who looks at environmental issues, we obviously pay a lot of attention to fundamental environmental jurisdiction questions. And we do regularly intervene to support ability to act on environmental issues at all levels of government. For example, the Hydro-Quebec case that Jacqueline mentioned, CELA was an intervener in that case, supporting the federal ability to act under the criminal law power in the case of toxics. In the case of spray tech, we were intervening to argue that municipal government has the authority to act under what most provinces have in their municipal legislation, which is general welfare type authority, in order to protect the environmental health of their community. In Castonguay, we intervened to support provincial jurisdiction over the environment. Furthermore, as Jacqueline mentioned, the concern CELA has is to make sure that all of the potential applicable heads of power that need to be considered by the court are in front of the court and well argued for the court, especially the ones that have been used for environmental jurisdiction in the past. And we consistently in our cases argue that jurisdiction over the environment doesn't belong just to one government or another. One or another is not better placed to deal with environmental issues. They all have a role within their respective spheres of jurisdiction, within their respective ability to act, within the scale and the scope of what they can do. And these things have to act hopefully together, but at the very least, we encourage all of the different jurisdictions to use the tools in their toolbox. So we do include federal, provincial, territorial, Indigenous, and municipal governments in that advocacy. And for example, in that spray tech case that I mentioned, which was about the authority to pass municipal pesticide bylaws, we specifically spoke to the Supreme Court of Canada in that case about the fact that even though there was federal jurisdiction over pesticides registration and there was, or authorization, and there was provincial jurisdiction over pesticide usage and licensing, there was room for municipal legislation over a cosmetic ban on pesticides for health reasons, and that all of these work together without being, without being in an active conflict. And this is a very important principle that we consistently advocate in our law reform, in our policy discussions, and in our litigation. Next slide. In addition, the precedent in this case is extremely important because we're very concerned to make sure that there's not a decision that will change what, to this point, for the last several decades, has been the understanding that all of the jurisdictions can take action over the environment. And we don't want governments to have to, for example, provincial governments, to have to start to second guess what they can do in terms of their jurisdiction over climate change and over the environment. As I mentioned, all the jurisdictions have to use all of the tools in their toolboxes. And furthermore, our client communities, in particular, because of their extra vulnerability and their tendency not to have a voice in some of these decisions while being impacted the most, need that recognition by the court. So that's the end of the slides, and I think the last slide is our contact slide for our website. And I'll turn it over to Jacqueline to moderate any questions and to give people pointers. The people who are experts at CELA in using Zoom are not with us today, so we'll do our best, but I think you can raise your hand and then Jacqueline and Andrew can unmute you, or you might even be able to unmute yourself, perhaps. And then there's the chat.
Okay, great. So feel free to put any questions that you might have in the chat box. And otherwise, yes, if you raise your hand, I can unmute you as well. Okay, we'll give you a few more minutes to think of questions, and otherwise, if you have any, feel free to contact any of us, and we'll be happy to respond offline. Okay, well, thanks so much for participating. We hope it was helpful, and thanks again. I'm going to log off. Okay, I found the unmute button. Thanks for the question, Michael. So the question is, are you suggesting that only the pricing aspect is the matter for which the federal government is responsible? So what the courts have found is that the way that the Canadian government framed the matter, which was greenhouse gases more broadly, and then refined to the cumulative dimensions of greenhouse gases, was too broad for the reasons that it would trample on provincial jurisdiction and raise concerns about the provincial carbon pricing acts and potentially other actions on climate change as being invalid because it would be covered by the federal POGG power. And so the way that the court, both the Saskatchewan Court of Appeal and the Ontario Court of Appeal, dealt with that issue is they still upheld the law under POGG, but they found that the matter that would be covered by POGG is much more narrow. So the Ontario Court of Appeal majority, it was a 3-judge majority, it was a little broader, and they said that it was minimum national standards on greenhouse gases in general. So they didn't tie it to pricing in particular as the means that had to be used, but did do a much narrower version of the matter than what the Canadian government had suggested. And the Saskatchewan Court of Appeal majority, the 3-judge majority there, and a 1-judge concurrence at the Ontario Court of Appeal did in fact tie to pricing. So the matter that was the most popular in the two courts is that it was national standards of price stringency to reduce greenhouse gas emissions. Okay, the next question is, do you think the Supreme Court of Canada would agree with the Saskatchewan and Ontario decisions? Well, we're not sure. We love our criminal law arguments. So we think they may go with that to avoid all of the pitfalls of POGG. But regardless, they're going to have to at least decide between the two. So those two are different. And so they both can't be recognized. But what those decisions do, as I just mentioned, is give space for provincial jurisdiction. So, you know, this concern that I think everyone shares, overarching concern about kind of accidentally boxing out provincial government jurisdiction, is addressed through the way that they've dealt with the matter in slightly different ways, or with, for instance, the criminal law power. campaign or law reform initiatives went alongside this? So a question in the room here is whether there were campaigns or law reform that went along with the court case. So there was certainly law reform in terms of when the act was released, making comments on, different aspects of it. So from CELA's perspective, we always focus on how it will affect low-income and vulnerable communities. And so we're always looking for any of these carbon pricing regimes to deal with what are regressive impacts of a price increase on things like gas and electricity, that kind of thing. So one way of dealing with that is the way Canada has dealt with it is by refunding the money. And the way that works is low-income and vulnerable people tend to be low emitters compared to others, and so they should be covered by a refund, and that should help, although there is a time gap. For instance, the old Ontario cap and trade regime, we were looking for provisions and mandatory requirements to use the money that was raised by the system for those communities, so to actually target programs and make sure that those communities were being specifically targeted with the money that was raised. Okay, so the next question is, if the Supreme Court of Canada upheld the criminal law, the law under the criminal law power, what would the matter be? So because criminal law is an enumerated ground under the Constitution, under Section 91, you don't have to determine a matter, actually. So you get to skip that whole step, which was quite fraught in both courts. The reason that you have to determine what the matter is under POGG is that you're basically coming up with a new subject area that will form part of that list of federal government power. So for criminal law, because it's already listed in the Constitution, you don't have to come up with a matter. The matter is criminal law. Okay, my colleague Joe here has mentioned that some commentators, maybe including him, have said that it was risky for the federal government to rely on POGG in this case, and what are the implications of Canada not relying on the criminal law power instead? So we, especially because there's decades-long jurisprudence using the criminal law power as one of the main ways to uphold federal environmental laws, we're concerned in particular about the way the Saskatchewan Court of Appeal dealt with our argument. And so we'd like to see at least, making sure that that law that's for decades upheld many different types of environmental law. So as I mentioned, toxic substances law, species at risk, other climate change law, including a renewable fuels requirement. We want to make sure that this decision doesn't change that, and that's still available to uphold federal environmental law. Okay, well, that's great. I'll wait for a couple more minutes in case there's any other questions. And if not, thank you very much for participating.
Yeah, I don't use it all in case anyone wants to have a minute or two.
Was that another question, Jacqueline?
Oh, okay. So the next question is, under the criminal law power, would it be the release of greenhouse gases that would be the criminal act?
So
So no, what it would be is releasing greenhouse gases without paying charge. So have to prohibit the underlying act altogether under the criminal law jurisprudence. You can either do an indirect prohibition, like what I just mentioned, the criminal law act releasing greenhouse gases without paying the mandatory charge. So I gave the example in my presentation of tobacco. I think it's a great precedent where what the federal government did, and this law was upheld under its criminal law powers, is prohibit tobacco advertising and prohibit selling tobacco without those printed health warnings that we're all familiar with. So they didn't prohibit the underlying act of selling tobacco or prohibit tobacco altogether, but instead used these indirect means with the of tobacco.
Jacqueline, to expand on Michael's question and your answer, is it fair to say that it's the legislation that defines what that prohibited act is, and thus puts it in the criminal law power? So it's not like it's criminal in and of itself, floating out there in the ether. It's defined specifically in the legislation.
Yeah, that's exactly right. And so the way you would look at that is you would have to look at, what's covered by the Act, of course, and then what it is that's actually being prohibited in the sections that deal with the prohibitions and penalties. So in our Act, the Greenhouse Gas Emission Pricing Act, there isn't a prohibition on emitting greenhouse gases altogether. There's prohibitions on releasing them without paying the charge and mandatory requirements to pay the charge, and then penalties if you don't.
And I think the analog for the smoking case is there wasn't a prohibition on smoking. It was all those other indirect things you mentioned. There's another question, Jacqueline, from Riz.
Oh, so the question is, if the Supreme Court finds the levy is a tax, would the levy as it's currently formulated be an invalid exercise of its power? I'm not sure I can totally answer this question. We haven't really delved that much into the tax argument. But there is a broad federal tax power, and then it would have to meet the requirements of Section 53. And so that's what the argument was about in Saskatchewan in particular, in looking at whether it was properly passed by the House of Commons, and then whether there was improper delegation to Cabinet to decide who the tax applies to and where. And the other piece of that I should mention is there was also that debate about whether it was a tax or a regulatory charge. So the finding was that it was a regulatory charge because it's the cost itself, which is the purpose. So the purpose is to incentivize behavior change through a cost on greenhouse gases being levied.
Oh my God.
Okay, well, that's great. Thanks so much, and thanks for the great questions as well.
Okay, I'll hang up last, Jacqueline, to make sure I don't mess it up for your recording system, etc.